Hey folks, how's it going? This is another ERISA Supreme Court update for 2020. This is on the case of Putnam versus Brotherston. And just a quick disclaimer again that this is for educational purposes, not legal advice or financial advice, and I'm not selling anything, and all opinions are my own. So these are the cases we've gone through. We're hitting Putnam right now, which is not actually a Supreme Court decision, but we'll get into that. This is about loss evaluation and index funds, and I'm going to go into a quick overview. So Putnam Investments versus Brotherston. The Putnam 401k plan was full of Putnam's own proprietary funds, which were mostly active. There were significant losses to the plan, mostly because of the high fees of those funds. The majority of the loss was due to the fees. So the question is, if fiduciary failures are established, can a loss be presumed to be attributable to that failure? And secondarily, uh, if calculating a loss, can you do it by doing a comparison to an index portfolio? Is that sufficient? So that's those are the issues, and that's pretty important. So that's why we're looking at it. So here are the facts of the case. Uh, from roughly 2009 to 2016, all the plan fund options were Putnam proprietary funds, so sold by Putnam itself, except for the self-direct window. So 6 months after the lawsuit was filed, the plan added a half dozen BNY Mellon index funds. So the plaintiffs had an expert who did a valuation, and the valuation compared the Putnam proprietary funds to comparable Vanguard funds in similar categories and to those BNY Mellon index funds that the plan used. So the performance was roughly 46 million worse than Vanguard and 44 million worse than the BNY Mellon. And the fees were for Putnam roughly 32 million more than Vanguard and roughly 35 million more than BNY Mellon. So of that performance, right, over half is due to fees, 2/3 or more. Um, so what did the First Circuit do? There's not a Supreme Court decision. We'll get into why I've included it in a Supreme Court update, but the First Circuit had its decision in October 2018, and the fiduciary bears the burden of proving that losses were not attributable to the breach. So that was one of the questions. This is a so-called burden shifting. And the other is, yes, you can show a loss by comparing to an index portfolio. So both of those questions were favorable for the plan participants, the plaintiffs, and bad for the plan. Um, there was also a disloyalty claim related to the proprietary funds that was actually dismissed, and they upheld the dismissal of the First Circuit. Since the Supreme Court denied cert, they implicitly accept the First Circuit outcome. They don't actually write an opinion about it, but they accept the outcome implicitly, or at least they don't think it's worth their time. So what about the amici? This is going to help. The amicus briefs will really help us sort of make sense of what people were arguing about to the Supreme Court, even though it denied cert. What were people arguing before cert was denied? So a lot of the private sector amici were arguing for a uniform standard for ERISA loss evaluation. So a lot of benefits experts like the American Benefits Council and ERIC and ERA, so basically lots of ERISA and retirement experts and employer organizations, they all argued that this burden shifting makes it easy to sue plans, and claims can often have little or no merit, and that they need a uniform standard to evaluate losses. And then ICI, which is an investment industry group, they endorsed the argument of the plan, fiduciaries, that there was a circuit split. So they were arguing for a circuit split because they wanted the Supreme Court to intervene to resolve it. And it was the plan who lost at the circuit level, so the plan wanted the Supreme Court to intervene. On the other side, the government, on behalf of the DOL, the Department of Labor, did an amicus, and they sided with the First Circuit below, essentially, on both the burden shifting and the index funds for loss evaluation. And they didn't think that there was much of a circuit split, or at least that it was not relevant here for purposes of loss evaluation. So the Solicitor General was endorsing the First Circuit, so even though there's no Supreme Court opinion, the court by denying cert functionally sides with the DOL and the plaintiffs over the plan and all of the retirement and ERISA experts. So analysis, like what does this mean? And the analysis is really why I wanted to include this. It makes it a little easier for plaintiffs to prove their claims. Basically, if there's a breach and there's a loss, you can presume that the breach caused the loss. It's a little bit more complex than that, but it's a simple answer. It also suggests that an index fund portfolio is legally safer, that basically plans with low cost index funds are going to be better off. Because an active fund or any fund that underperforms an index fund net of fees might by itself be used to prove a loss. So that's a significant risk. So the most cautious move is to benchmark all the active funds against index funds as well as other active funds. And if they don't outperform the index, then you should consider them underperforming. That's the most cautious way to interpret this. Now, it's not per se, you're not absolutely required to get rid of active funds or anything like that, but underperforming an index could be used to prove a loss. So that is a significant outcome. That's why I've included it. It's a pretty big development. It's been sort of a long time coming, but that's why this merits some inclusion, even though there's not an independent Supreme Court opinion. So my commentary here is that active funds are just a legal risk, and this is sort of the development that's been brewing in general in the investment industry, and especially within ERISA, that after you consider all of the fees that go towards active funds, they are often not worth anything better, and sometimes they're worse than like a low-cost passive index fund, and that maybe we should just be avoiding active funds to some extent. You especially want to avoid any active fund that's correlated with an index fund, obviously, because that means you're not getting much benefit. You're going to pay more for active cost, but you're not going to get much more than index performance, and maybe a little worse. There's also a proprietary fund risk, which is another reason this is interesting, even though the disloyalty claim was dismissed. But proprietary funds, they're just a big legal risk. If you're looking net of fees, the return should be better than all of the other funds in the category, really. That's the safest way to include a proprietary fund. It should just be the best. And if it's not the best, you should be very cautious because they're not per se disloyal, according to the First Circuit here. But the risk is high, especially in the long term, because the optics just tend to favor the plaintiffs, and it's not a very favorable fact pattern if you are a planned fiduciary. And obviously always look at your fiduciary basics, right? Fees and balancing return and risk. That's ultimately what this is about, but gives you a little more context that maybe index fund is more important. So ultimately, what are the takeaways is going to be a lot of what I just included, which is the plan losses can be shown by underperformance of an index portfolio, right? And that the legal risk, if your active funds don't exceed index after fees, that's just significant, right? It's not without its risk to have your active funds underperforming index net of fees. So those are the cases. We've got one more yonder that I'm going to go through, but I wanted to include this one even though there's not an opinion because it's pretty important. So I think that we're seeing a larger trend towards index. A lot more people have been focusing on them for years. It's definitely filtered out into general, more amateur investment awareness. So a lot of people are aware of them, these low cost and even zero cost funds, which are generally going to be index and nearly always passive. That awareness is really become widespread, and so plans really need to consider that and should consider scrutinizing their active funds, looking towards the future, and decide whether an active fund is really earning its place, considering both the returns and the fees. So I hope you found that helpful. This is an important case, even though it's not an actual Supreme Court opinion, and I hope to see you in the final case yonder. Thanks.